Just want to make sure that everyone knows that also, in addition to that, the Office of Advocacy within the U.S. Small Business Administration has provided materials to us as well with regard to the overtime rule, including recorded webinars and additional resources like compliance guides. And at the bottom of your screen is a compliance hotline. Again, this will all be on PHC's website, but I just wanted to make sure that people realize that the Office of Advocacy has helped us as well.
Thanks so much. Also, thanks to the PHCC for allowing us to conduct a seminar. As many of you all may know, we conducted one several months ago, and there have been some communications, some miscommunications as relates to the new rules and regulations. So I'm going to provide some initial commentary here before we get into our slideshow and hopefully answer some of those questions. The first question we've been getting is, are these regulations going to be delayed? As you may know, the House prior to the election, did pass a bill to delay these regulations, primarily the regulations dealing with the guaranteed salary basis, moving it from $23,660 to be exempt from overtime up to $47,476, which is the crux of our conversation today. Of course, that's only one branch of the three-branch government. It would have to go to the Senate. The Senate then would have to pass that, and then, of course, it would have to go to the President's desk. And President Obama has already stated that he would not consider that. Obviously, I shouldn't call it a piece of legislation necessarily. These new rules were never voted on. These were issued by executive order, and the House, Senate, the Congress never had an opportunity to consider or vote up or down on these rules and regulations. So they are not being delayed, and we need to plan on compliance December 1st. With that said, we do have a new president, as you all may know. You may have heard that. President-elect Trump has stated that in his first few days, he will review all of these, quote, executive orders, these orders that were issued by the previous President Obama, that did not work through the typical process of up or down votes to the House or the Senate, and consider simply by the stroke of a pen removing these executive orders. Of course, again, this one that we're talking about today, the changes that we're talking about today, could be one of those that he could change, could remove completely or make revisions. I don't know where that's going, and watching and monitoring Washington and the political commentary and some of the things that his team have already discussed. If his discussion and communications have not included this topic, it doesn't mean that he won't get to it, but I think some of the practical challenge is if an employer in December changes someone's salary or increases their salary or their pay plan to come into compliance, and then changes are coming forth maybe in February or March, it might be difficult for employers to go back and forth. But we'll simply monitor that. I'm sure PHCC legal team and government team will be monitoring it, and you'll be notified should there be any changes. But as of today's call, plan on complying with the rules and regulations that we're going to be working through. A little bit about SESCO. We were founded in 1945, and the only reason why I bring that up is that in 1944, our founder, the founder of SESCO, Joe Lawson Sr., worked for the Department of Labor. He was actually a Department of Labor wage hour investigator. He was enforcing rules and regulations on minimum wage, overtime, child labor. He worked for the government. At some point, a federal judge said, Lawson, you need to go out and help business and industry comply with these rules and regulations. There's no one out there helping them. So that's what he did. So he founded SESCO in 1945 to help employers specifically with this subject. Our toolbox has expanded into other areas of labor and employment law, but our history is rooted in this topic that we're talking about today. The other thing it's interesting to note, you would think after all of these years, since 1945, actually the act was passed in 1938, but you'd think after all of these years basic things like minimum wage, paying employees minimum wage, and paying overtime would be a non-issue. Well, to the contrary, this next slide comes right off of the Department of Labor website. If you want some interesting reading, go to the Department of Labor wage hour website, and there's quite a bit of information on there about what they do on behalf of your employees. But anyway, wage and hour, non-compliance to wage and hour, primarily not paying overtime correctly to employees, has been the #1 employment violation for employers across all industries and professions. It is not sex harassment, it is not EEOC discrimination charges, it's not family medical leave, or all of the rules and regulations that we must comply as business owners and managers. It is the #1 violation, liability violation, financial liability is non-compliance to this legislation that we're talking about today, primarily not paying overtime correctly. And in fact, this slide here talks in 2015 about $246 million in back wages were collected for 270,000 workers. And as you read on, again, the government talks about another year of meaningful progress toward our goal of ensuring a fair day's pay for a fair day's work. So they're very proud of what they do. And if anybody on this call, or if you know someone who's ever been through an audit conducted by the federal government, it is not a fun thing. Of course, with the changes this year, we expect this trend of the #1 violation being overtime violations moving forward into 17 and beyond. It's just something that we're just going to have to pay attention to. But compliance is attainable if we understand the rules and regulations, and of course that's what we're attempting to do today. Another slide off of the Department of Labor website talks about strategic enforcement, and basically what this slide talks about in 2015, in 79%, 8 out of 10 cases, in essence, 8 out of 10 investigations, they're going to find something. So even though we didn't mean to, or didn't intend to, or just didn't understand, most of us are violating the rules and regulations in some form or fashion. That 8 out of 10 violation results in about $9,000 per employee in terms of back wage liability. What we get, or what we hear from our clients is, okay, Bill, we hear you. We hear that there's significant liability. We understand that the rules and regulations are complicated. But how does a Bill Ford's organization, how does Bill Ford Contractor, how do we get audited? How would the government identify that we're in non-compliance? And this would happen in one of two ways. First is the most typical, although the trends are changing a little bit, but this is the most common, most typical way that your organization might get audited. Typically, it's a disgruntled employee. Maybe we as an organization have held someone accountable for poor behavior or poor performance. Maybe we've written them up, verbal or written counseling. More than likely, maybe it was a termination, or someone quit in frustration. And if you've ever been through a separation meeting with an employee, you've probably heard them say, well, I'm going to call the labor board. And basically that's what they do. There's an 800 number for a regional office. These employees call up the Department of Labor, make a complaint. You got to understand at that point, particularly now, and I got to be careful in terms of talking right, left, or independent. I got to be careful about talking about politics, but we must understand, regardless of which side you're on, these past 8 years have been very difficult for most employers. It's a very aggressive agency, and I can explain some of the cases that we've been dealing with here currently and explain how aggressive they are. But what happens is, if that employee, that ex-employee maybe, calls the Department of Labor, they make a complaint, you need to understand that that investigator within the Wage Hour Division or EEOC or any other government office, frankly, they're going to assume that that employee has a story to tell and is factual. They're going to do the intake. They're going to find out what your business contact information is, and they're going to contact you and let you know that they're coming in to investigate your compensation practices. They're not going to let you know that if it were a complaint by an employee or who the employee might be, but that simply they're coming in. At that point, if you get contacted, I've even had clients get called on the telephone or even on their cell phone. If you get contacted by the Department of Labor, at that point, it's a good thing maybe to contact us or someone who has experience in working with the Department of Labor. We can't necessarily change what's going to happen, but we can help you prepare for that audit in terms of how to prepare your records, what to provide, how to provide it, and how to communicate with the investigator. It may not make any violation go away, but it might make the process easier, and sometimes it kind of heads them in different directions. But anyway, once you're notified, you're going to have to let them come in. They're going to conduct an audit. And if they find any violation, again, typically it's not minimum wage. Most employers are okay in paying minimum wage, but it's normally paying individuals overtime correctly. If they find a violation, what they're going to do is they're going to roll back 24 months from the date of the investigation, and those previous 2 years, any current employees, as well as previous or ex-employees, they're going to identify those folks. They're going to calculate what they think they are due, and they're going to come back and they're going to sit down with you in what they call a closing conference, and they're going to say, here are our results. Here's what you owe. In essence, pay it. And if you say, well, I would sure like to look at this and verify it and have my professionals look at it, they're going to say, well, if you do that, we're going to sue you. They do all kinds of things to threaten you to close that case immediately. You need to know at that point you have every right to have that information reviewed, and they're not going to go off and sue you. So always have their work reviewed, because they make mistakes as well. But the point is they roll back 2 years. So your liability typically is 2 years of back wage liability. They can go back 3 years on you, but that's normally for what we call a willful violation. You willfully violated the law. Maybe they've been in your organization before, fined you, told you that you were in non-compliance and how to get into compliance, and you said, heck with the Department of Labor, they'll never be back in here. Well, sure enough, that they're back in. So they can go back 3 years at that point. What we're seeing, in addition to that 2 years of back wage liability, I've got cases in Missouri, got one in West Virginia and other states, and this has just happened in the last couple of weeks. They are also issuing, in addition to the overtime back wages back 2 years, they're also issuing what they call liquidated damages. And what that means is they are issuing immediately, whether you were willful or not, or ever been in trouble or not, or even if you were very cooperative, they're issuing liquidated damages, which basically means they're taking that 2 years back wages and they're multiplying it by 2, just because they can. Again, they're very aggressive. In fact, I've got a client that they're threatening that they're going to pay their attorney fees in Washington. So the back wages and the liquidated damages, it can get expensive very quickly. So that's one way. The other way that you get in trouble is that an employee does not call the Department of Labor, but they call in an attorney. And that normally this is in larger metropolitan areas, not necessarily, it doesn't have to be, but this is where your attorneys are primarily marketing on the news and other places, billboards, etc. And the employee could call in an attorney. They file a suit in state court. They go through the same process to identify if there's any overtime back wages due. And we must understand at this point, automatically through state courts, they're going to get their 2 years back wage liability. They're also going to get their liquidated damages, and part of the state court system is you're going to pay the employee's attorney fees, which can be quite expensive. So that's typically how folks get in trouble. Now this year it's a little bit different because there's so much press, there's so much information around these new rules and regulations. If your employees aren't asking you about this, trust me, they're on the internet, they've read it, they've seen something on the news, and maybe they're not disgruntled, but they're intrigued, and particularly the younger generations, the millennials of the world, will contact DOL because they just think they're due the money. So that's how we typically are investigated, and that's how we typically get in trouble. So what we're going to talk about, what we're going to do is I'm going to walk through this story very slowly. I'm going to start from the beginning with the basics, which leads us up to December 1st. And this background is very important to understand before we make any changes in pay plans, etc., because there's lots of, again, misunderstanding about the rules and regulations. So all those several hundred pages, that probably thousands of pages long, we have Department of Labor interpretations, guidance, cases, all kinds of things that guide these rules and regulations. When it comes down to it, there are three basic things that we must do for all employees. We all know this. We must pay minimum wage. Of course, federal is $7.25. There are, of course, other states throughout the country that have issued their own minimum wage. If you're in one of those states, you understand that. Also, start monitoring cities and counties. We have clients in various cities and counties where they're passing their own minimum wage. So just as a heads up, you must pay the higher minimum wage of whichever is the highest. In addition, each employee must maintain an accurate record of time, basically a time record. It can be by hand, handwritten time. It can be by punch. Of course, nowadays we have lots of electronic means. If you have folks out on the road, which most of you do, I'm sure, many are using GPS systems now. And then number 3 is pay overtime at time and one-half their regular rate of pay for hours over 40. Again, monitor your state. We've got California and some other states that require more aggressive overtime hours, and I'm sure if you're in one of those states, you'll understand that. So those are the basic 3 requirements when we're compensating employees as issued by the Fair Labor Standards Act. The Fair Labor Standards Act goes on to say that there are some exemptions, that if the position meets one of the exemptions and meets the guaranteed salary requirement, we don't have to worry about a time record or paying overtime. So it's our charge as a consulting firm, it's our charge to help you understand what these exemptions are so that we can avoid overtime payments. These white-collar exemptions, as you'll see, have been on the books since 1938. Very little changes in these over the many years. We thought the Obama administration was going to tinker with some of these, but they did not. Basically, the only thing that they've done is raised, more than doubled the salary requirement, which we'll talk about in a minute. So to start this conversation, we must understand, and I can't tell you this enough, that to avoid overtime, the position must perform duties that meets one of these white-collar exemptions. We're going to walk through each one of these pretty slowly. So there are duties, duty requirements, and the position must make the guaranteed salary. The common question that I get is, well, Bill, if we guarantee someone $47,476, we don't have to pay overtime, correct? Wrong. The position needs to meet one of these exemptions, which we'll cover, and meet the salary test. So with that said, we're going to walk through these. The first is the executive exemption. This is someone in management, managing 2 or more employees, and that's black and white in the regulations, 2 or more employees. Now, if you got a number of part-timers and it comes up to 2 full-time equivalents, that's okay. So 2 or more employees, and they're managing most of their time. That means that they're managing, hiring, firing, directing, coaching, counseling, scheduling, performance reviews, all of these managerial duties. They are not performing plumbing, HVAC, or other hands-on contracting work. So if you have a manager, if you have a lead, if you have someone out in the field doing this type of traditional hands-on work, and you got them on a salary, we may want to talk further. And let me stop right there. Our commitment to PHCC for this opportunity to get in front of you folks is in our handout. You have my email, you have my phone number. Call us because we're talking about lots of technical things here, and you're going to have specific pay plans and questions. There's not going to be any charge to that, and I'll be happy to walk you through and answer any questions that you have. So if you have anybody you're paying on a salaried, no overtime basis, and they're managing 2 or more employees, but they're also doing hands-on work, we need to talk because they potentially could be due overtime. Next one, administrative exemption. By title, administrative, it appears that this might apply to all of our in-house administrative personnel. It does not. It's a very high level, a very hard to achieve exemption. Basically, this exemption is reserved for department heads, folks who manage functions, folks who are managing or making decisions on behalf of the organization, and they simply don't manage 2 or more employees, whereas the executive does. These folks are making significant decisions on behalf of the organization and or your clients that you serve. As an example, a controller or a chief financial officer would be an administrative exempt position. They're working and communicating with the bank. They're managing cash flow. They're determining on their own when to pay bills, or they're developing budgets and monitoring compliance to that, managing benefits, all kinds of very high-level things. Contrast that to your accountant, your payables, your receivables, your payroll, your secretaries, your purchasing agent. All of those types of positions are typically non-exempt and do overtime. So if you have someone in-house not managing 2 or more employees and you're paying them a salary, we need to talk to determine whether or not they in fact are administratively exempt or not. And this is important because what I'd hate for you to do is in any of these exemption cases is raise the person's salary to $47,476 thinking you don't have to pay overtime, and doggone it, you get audited and the Department of Labor says the position is not exempt and you have to pay overtime. So let's make sure that your exemptions are correct before you start tinkering with pay plans. Next one's pretty straightforward, probably not going to apply in your all's profession, but this is what we call professional exemption. I go to a college, typically obtain additional degrees to practice a specific profession. Doctors, lawyers, teachers, nurse practitioners, CPAs, that's what we're talking about. Now, if you're very large, potentially large, and I'm thinking out loud here with you, if you require an engineer, civil engineer, or some type of engineer, and you require a 4-year engineering degree and or mechanical engineering degree, and it's required, not preferred, then someone like that could fall under the professional exemption. But other than that, you're probably not going to have any other employees meet these. Your certifications or your things like Bill Ford's got a 4-year business degree, generic business degree, that's not what we're talking about. We're talking about very specific professional degrees. Next one's a computer exemption. Again, unless you're awfully large and you have someone in-house programming, I'm not talking about CAD work or things of that nature, but I'm talking about programmers, programming software, program analysts. They can be exempt. This is not your internal network administrator, your help desk, your webmaster, or these kinds of folks. Those folks are typically due overtime. Next one, if you happen to have someone in outside sales, this is not counter sales, it's not inside sales, it's not anyone within your facility or even in their home if they're working out of their home. This is someone out in the community calling on contractors or other customers, and they're making sales. If they're doing this 51% or more of their time, basically 2.5 days or more per week out in the community making sales, there's no overtime due. And in fact, and this is the only one, there is no salary requirement for outside sales. You could put someone on minimum wage, you could put them on commission, any type of pay plan that you would like, but there's no such minimum requirements for these folks. Next is highly compensated. It's not practically used most anywhere. You're guaranteeing someone $134,000, and also they've got to be making independent decisions. They've got independent discretion and judgment, and so it's probably not an issue for most. So those are the exemptions, and as you will see in this slide, they have to meet one of these exemptions. Your employees have to meet one of these exemptions, as I just talked through, and make the guaranteed salary basis. Currently, that guaranteed salary is $23,660 or $455 a week. Not been an issue for employers for many years. But in this case, this executive order issued by Obama more than doubles that to $47,476 or $913 a week. So to be exempt from overtime, we must again meet one of the exemptions and meet the salary requirement that I'm discussing. This slide that I skipped over talks about, this is off the Department of Labor website, it talks about the estimated number of employees who are exempt now, maybe making $23,660 or more, but they're not making the $47,476. They estimate that this is about 4.2 million workers that fall in this donut hole that you as employers are going to have to determine what you're going to do with them. Meaning, are we going to increase someone's current salary to the new threshold of $47,000 and continue to not pay overtime? Or are we going to have to make them non-exempt and put them on some other type of pay plan, require them to keep a time record, and then pay overtime in some form or fashion? And I say form or fashion because there's some options here that we'll talk about. A little personal commentary here. What frustrates me as much as anything is that this slide doesn't recognize a couple of things. This slide, when you go to the Department of Labor website, is inferring that that's what employers are going to do. That they're going to go out there and they're going to raise everyone to $47,476, and thus everyone's going to get a raise. That's what the media is saying. That's what the Labor Department is saying, and that's just not practical. That's not going to happen. Most employers are working under very tight margins, and to go out and increase someone's salary a significant amount is just not practical. And I say that labor cost is our largest single controllable cost. Things like light, heat, electric, copiers, computers, paper, supplies, office supplies, rent, mortgages, all of those kinds of things are determined, those expenses or costs are determined by someone else. We as the employer can decide, number one, if we're going into business, number two, how many people we're going to hire, number three, what we're going to pay them, at least minimum wage, overtime, how many hours we're going to schedule them, what benefits we're providing, etc. So the employer that manages these labor costs, I guess the best or actively, normally are the more profitable ones. Number two, also, let's think about, let's say Bill Ford has been with your organization for 15 years. I've been loyal, I've been there, and let's say that I'm making $48,000. I'm over the $47,476. You don't have to do anything with me theoretically. What about that person that maybe is at 44, 45, and they're going to get an increase or a raise to $47,476? What does that do to my morale? What does that do to my internal equity? What does that do to me? Well, any increase in your compensation to meet these requirements will have an effect, directly or indirectly, on all your other employees. So, bless their heart, I appreciate the 4.2 million workers across the country, but everyone's can be affected, negatively by this process. One other thing that we can consider, if you have your salaried exempt employees who are not receiving overtime now, if you have those folks on any type of bonus system based on productivity or sales or customer service scores or whatever it might be, you can apply up to 10% of the annual requirement of $47,476. You can apply up to $4,700 here, as you'll see on this slide, and change, against the $47,000. So basically, you can pay someone $42,700 and change, and make up the difference in this bonus of $4,700, and that gets us back up to $47,476. But it's only a maximum. You see the maximum there is the $4,747. You also have to look at this quarterly, excuse me. So you have to settle up quarterly. So you have to look at the salary plus the bonus on a quarterly basis to make sure that we are settled up to the $47,476 on a prorated basis. It's not a lot, but it does give you some wiggle room if you do have some commission or bonus program that you can use to offset the guaranteed salary requirement. Next, I'm going to go quickly over to one other option, and I apologize that it's this deep in the slide. There is one other option that you can use, and any retail business can use this. Maybe I'm the corner store selling mattresses, or maybe I'm an auto service fella who has technicians on a commission or flat rate system. Any retail business as defined can utilize this exemption. This exemption sort of picks up where the white collar exemptions leave off. This is for your field staff or sales staff, maybe inside sales staff that you might have. If you're considered retail, and that means 75% of your gross revenue on a 12-month rolling basis, it's considered retail. This is repair. This is service. This is not wholesale. This is not contracting. This is not remodeling. This is not wholesaling goods and services to other businesses. But this is retail work with bill forward residential plumbing work or HVAC work, or it can be commercial, but it's retail in nature. It's repair and service. So if you are earning 75% or more of your gross revenue from this type of retail work, and then your employee is on a commission program, and the tolerance there is 51% or more on commission, so therefore you could have an hourly rate plus commission. You could have a salary plus commission, or you could have it all commission, whatever it might be. So 51% or more of my gross income, my earnings, come from commission. And I average, I don't have to make $10.88 per hour, but I average that, meaning that at the end of the week, you look at my total earnings, hourly rate plus commission, all my commissions, salary plus commission, whatever I've earned total for the week, you divide that by total hours worked, and if I'm making $10.88 or more, then you don't have to worry about overtime. So this might be a way to avoid, if you have folks working lots of hours, you might be able to tweak a pay plan or come up with a pay plan where it is incentivized based on what they turn. And some in your profession do this, and they do it very successfully based on what they turn. So if a job says it takes 2 hours, they do it in an hour. They do a good job. They beat the system, and they're moving on to the next one. They get the 2-hour total. You all know this better than I, but that's an opportunity. So this, if you can put employees, traditionally hourly employees on this, field employees on this, again, you don't have to worry about overtime. A couple of things. To measure the 51% or more of gross income from commission, you can look at that monthly up to 12 months. So you may want to look at this quarterly and look at my earnings, look at my hourly or salary rate, and then my commissions, and see if I'm meeting that tolerance test. You may be in a market where it's very seasonal or otherwise. You may want to look at it annually. So there's lots of flexibility there in terms of measuring that 51% or more. But you do have to measure the $10.88 per hour on a work week by work week basis. But I'm sure if you have employees that aren't making or generating at least $10.88 per hour, they're probably not going to survive in the system anyway. So I just wanted to throw that out there. Now, the employee still must maintain an accurate record of time so that we can verify these things, but that's certainly an opportunity if you want to develop such a commissioned or incentivized type of pay program. So let's talk about options. Let's say that we have employees in this donut hole, meaning they're currently salaried, exempt. We know that they're exempt under one of the exemptions that we talked about. They're being paid on a salary basis, but they're less than the $47,000. So come December 1st, you've got some decisions to make. First is do nothing, roll the dice. I raised some eyebrows here, but I can tell you I've audited clients for 28 years, and some of these clients multiple times, and they'll look you dead in the eye and they'll say, well, Bill, I hear you, but I'm going to pay my secretary on a salary and I'm going to work her 50 hours and I'm not paying overtime. I'm going to take that chance. And they've gotten away with it for years. The problem with this moving forward come December 1st is that, again, there's so much press, so much media, there's so much information out there that if your employees aren't already asking you about this and how it's going to affect them, trust me, they're out there talking to someone else or their buddies or reading it on the internet. So that's certainly not recommended. Number two, raise them to the $47,476. Easier said than done. But if maybe somebody's at $46,500 or maybe they're at $45,000 or something like that, maybe they're due a raise. Maybe you increase them to the $47,000 and not give them a raise or something next year. I'm finding that most are not doing that. That they're just not going to pay and increase salaries that much because it also could again impact other employees and they're going to expect something as well. So if we can't keep them exempt, meaning that they're not due overtime and they're making $47,476 or greater, or a combination, as I said earlier, the salary plus the bonus to equal $47,476, then they're going to be non-exempt, meaning that they're due overtime. Non-exempt doesn't mean just an hourly rate. You could put them on a job rate, you can put them on a daily rate, you can put them on a piece rate, you can put them on a fluctuating work week. You can put them on a salary with overtime. There's all kinds of pay plans that you can consider. The key factor being they must keep a time record and they must receive overtime for hours worked over 40. The two obvious, without getting into too much detail in some of the other pay plans, the two obvious ones for you to consider is changing someone from a salary to an hourly rate, and then paying time and a half over 40, or if you're in a state, time and a half over 8, or whatever the rules and regulations state. Sounds simple enough. Most of the time it'll work. Probably the more common transition. But you need to think about two things here. One's very obvious, one is not. The one thing that's not obvious here that we may haven't thought about is that employees who have been receiving a salary like that guarantee. They know what they're making week in and week out, and thus they've budgeted their life around that salary. Maybe it's a car payment, a house payment, maybe it's other kinds of expenses at their home, etc. And if you tell an employee that we're going to take away that guaranteed salary and we're going to put them on an hourly rate, it scares them to death. Because if they don't work their 40 or 45 or 50, whatever they're used to, if they don't work the hours, they're not going to be made whole. So all of a sudden in their mind, their earnings are at risk, and they don't like that. The other thing is, of course, for you folks is, well, 99% of your employees are good folks. They're honest folks. They want to do the right thing. But trust me, once they get a taste of that time and a half over 40, it may not be December 15th. It may be July of next year, and it may not be intentional. But trust me, the hours are going to start creeping up. They're going to come in early. They're going to stay late. They're going to work through lunch. They're going to find reasons to work. So if you go to an hourly rate, think about those two things. particularly for you folks on the call, if you go to an hourly rate, make sure you have a good feel for how many hours it takes to get the job done, so that they're not riding the clock on you. The other option is the fluctuating work week method of payment. And I'm going to discuss this a little bit, but I would urge you, if you consider this, to call me. I'd like to walk you through some of the details of this. It's not complicated, but just reassure you on how it works, and also how, more importantly, you're going to communicate it to your employees, because you're going to raise some eyebrows here in a minute, and as you can imagine, they might as well raise eyebrows too. So let's just talk about this. So maybe you don't want to go to an hourly rate with time and a half over 40. Maybe they don't want to either. And that's what we're hearing a lot, is that I don't want to go to an hourly rate. I want to keep my salary. Well, under the fluctuating work week, we can continue to pay a salary. Now, this salary does not have to be $47,476. There is no salary requirement associated with this. The only requirement is that you divide the salary divided by hours worked, and it simply needs to yield minimum wage, $7.25 on a federal basis. So more commonly, what we would do is we'll bill forward. You're at $35,000. You're my office accountant or controller, if you will. I can't get you to $47,476, but I want to keep you on a salary. So we continue to pay bill forward $35,000. The advantage to the employee is I don't go to an hourly rate. I do have to clock my time, but I don't go to an hourly rate, and I know what I'm going to make week in and week out. The negative for you as the employer, potential negative, is that this is a salary. This is a guaranteed salary for all hours worked. So let's say Bill Ford comes in and works Monday, and then I'm out Tuesday, Wednesday, Thursday, Friday. I'm out sick. And in fact, it's late in the year, and I've exhausted all my vacation. I've exhausted all my PTO or paid time off or sick leave. Let's say that I don't have any benefit to cover for my time. Because it's a guaranteed salary, you as the employer must pay my guaranteed salary. You can't deduct for that guaranteed salary or from that guaranteed salary. Now, if I miss an entire work week out sick or on extended leave or whatever it might be, you don't have to pay me. But if I work a short week, less than 40, you're going to pay me my guaranteed salary. Now, the reality is those folks that you have on salary now, you're probably not reducing their salary, if it ever. So it's probably a minimal or moot point, if you will. The advantage to you as the employer is that you pay half time for hours over 40, not time and a half. And the reason why the Department of Labor allows this is that if the employee works less than 40 and they get their salary, they get their salary. So it's guaranteed. So it's good for the employee on the bottom, less than 40, and then over 40, we, through the guaranteed salary as the employer, have already paid all straight time. We've already paid time of time and a half in our salary. So if I work 15, if I work 30, if I work 40, if I work 50, my salary covers all straight time. So the only thing that you would owe in addition is half time over 40. The example on your slide is someone's making $600 a week. You divide their hours, total hours worked, not 40, but total hours worked in the salary for that work week. So I worked 45. My hourly rate is $13.33. And again, I'm paying half time. So I take half of my hourly rate, which is $6.67, and I multiply that by 5 hours. So my overtime due is $33.35. So your overtime payments are greatly reduced, and in addition, there is no incentive for the employee to really ride the clock. So the advantage to the employee, they get their salary, they know what they're making, they're not going to an hourly rate, and the advantage to you is you're compliant with the new rules and regulations, and you're paying a half-time rate versus time and a half. Let's let's assume that maybe you're going to an hourly rate with time and a half over 40. You're probably going to go through this same calculation. You're going to take Bill Ford's current weekly salary. You're going to come up with an average hours work of 45, and you're going to say, well, we need to pay him $13.33. If I work overtime, that overtime under an hourly rate, time and a half, is $13.33 times time and a half. That gets me over 20 bucks. And you multiply 20 bucks times 5 hours, we're in excess of 100. So you can see how quickly that can escalate in terms of cost. So you're paying a third of what it would be. So again, it can be win-win. Now, if you're thinking you're going to implement this and work people 60, 65, 70 hours, they're going to get frustrated because you you divide total hours worked, RE 55, 60, 65 into the salary, and thus that half-time rate gets to be pretty small, and they'll get frustrated. So be careful on how you implement it and not take advantage of your employees, which you all aren't going to. But certainly this is an optional pay plan for you, and it can work very well as long as the employee thinks about their annual earnings. And you can put anyone, it doesn't have to, you can put your receptionist, you can put anyone in your organization on this program if you'd like, and to reduce your time and a half overtime payments. So that kind of brings us to where we are and where you're going to have to look internally at your organization. You're going to have to first, what I would strongly suggest is look at your exemptions, the white-collar exemptions, before you change any pay plans, and let's determine whether or not they're truly exempt under one of the exemptions. Then let's also talk about hours of work. If they're working lots of hours, we may look at other types of pay plans or the fluctuating work week. If they're working 40, let's say you have an administrative assistant on salary and she's working 40. You may not want to change anything. You can put anybody on a salary, and remember, the only requirement you have is to pay overtime over 40. We've got clients who have people working 42, 43 hours. What they're going to try to do is reduce their hours down to 40, making them take longer lunches, or split up work, or look at varying schedules. So there's things that you can do internally before you automatically start making these changes. As you work through it, always consider, particularly for your field folks, you could look at this retail 7I commission exemption. If they're on any type of commission program, we can avoid overtime that way. So lots to think about, lots to take in, lot to consider. But again, we're here for you at no charge through our relationship with PHCC. It can get very complicated and technical. So rely on us as you need. Rest of the program here real quick. What I'm going to do is I'm going to talk about common violations. Remember when I opened up the program that overtime violations, primarily overtime violations, or violations with this wage and hour rule regulations, is the #1 violation for employers. What I'm going to walk through is why it's the #1 violation. And these violations will talk about non-exempt, either hourly or fluctuating work week or other types of pay plans, but these employees are due overtime. This does not apply to our true salaried exempt folks making $47,476 or greater and meet one of the exemptions. First trap, first common mistake, and this is based on our auditing practices here at SESCO. The first is paying someone on a salaried basis. Oh, we think they're exempt. We're going to pay them on a salary. We're going to work them 45 hours, and we're not going to pay them overtime. Wage and Hour Department of Labor comes in and says, oops, sorry, they're due overtime. That's the number one trap. People like office managers, accountants, marketing, IT, purchasing, payables, receivables, those types of positions, be careful with. Again, as I said earlier, make sure that your exemptions, you understand and apply your exemptions correctly so that you don't fall into this trap. Number 2, and I can't tell you how many calls we've had over the past several months where employees said, the heck with this. I like my salary. I don't want to go to an hourly rate. The company's been good to me. I don't want overtime. I don't want to go to hourly punch a clock overtime. I've got flexibility. I could come and go. As long as I get my job, they're happy. I will sign a contract. I will sign an agreement. I will waive my overtime. Problem with that is if the federal government comes in, that employee may not have complained, but maybe there is an audit. Maybe it's random. Maybe it's a complaint. If they audit your pay practices and they find this person who's due overtime but says they don't want it, Wage and Hour is going to say, take the money. If you don't take the money, we're going to put it in the Treasury. And I have literally had almost one case, almost 100 employees line up, walk through the office where the wage and hour investigator was with a statement saying, I don't want my overtime. I like these folks. It's going to put them out of business. I don't want this. And one by one, the investigator said, sorry, we're going to put the money in the Treasury. So employees can't waive their rights even though they agree to or like the way they're paid. Number 3, be very careful about working time. And this is where your overtime violations come in. For any period of time to be unpaid, let's say that you have unpaid lunch. If it's going to be unpaid, it must be at least 30 minutes or longer. So if you're going to have a lunch period, let's say Bill Ford clocks out at 12 o'clock, and I clock back in at 12:30. I did no work. I didn't answer any phones. I didn't do any work. I was in the break room or went down to the local Burger King, and I took 30 minutes for lunch. You do not have to pay me. That can go unpaid. If Bill Ford clocks out at 12 o'clock and back in at 12:15 because I'm ready to get back to work, or I just took a short break or a smoke break or bathroom break or whatever the break is, or lunch break, that 15 minutes is to be paid. And the problem with electronic time records nowadays is that 15 minutes goes in the system, it doesn't recognize it as paid, and it doesn't pay it. If Wage and Hour reviews your records and they see these short clocks, 10, 15, 20 minutes unpaid, they're going to make you go back 2 years and pay it. And of course, that can also throw employees into overtime. If there's 2.5 hours a week in lunches, that's probably 2.5 hours of overtime, so it can get costly. So always monitor, always edit your time records at the end of each pay period or end of each week and make sure that these things are correct. Obviously, you're going to have to pay for any required company meetings or any training that we have, whether it's on or off-site, even if the training is for the employee's benefit. Maybe it's a certification or something like that, and maybe we're even paying their expenses to go and whatnot. That is still paid time. As I said, working through lunches. Be careful about employees coming in, loading up trucks, preparing for the day, and then clocking in. Any pre-work, any getting ready for the day, any cutting on lights, computers, etc. All of that is working time. Now, conversely, what we see more than this example, what we see more commonly is Bill Ford comes in early at 7:45. The first thing I do is go punch a clock. The next thing I do is go to the break room and hang out with the buddies until 8 o'clock. You have every right to edit your time records. You have every right to change that 7:45 to 8 o'clock. Have the employee sign off on it. You sign off on it. Maybe even put a little verbal note in his file or her file stating we talked about this, don't clock in early. But if they didn't perform any work just because they clocked in doesn't mean you need to pay it. So also edit your time records for that kind of, coming in early, staying late or whatnot. Number 4, if you're paying any type of bonuses other than what I talked about earlier, if you're retail and you're using the commission exemption, if you're paying any type of bonuses, safety, attendance, productivity, sales, any kind of bonuses, overtime must be paid on those bonuses as well. So if I worked, I'm an hourly employee and I get time and a half over 40. Of course, I'm going to get my 5 hours of overtime. But if I, in that work week, earned any type of commission or bonus, overtime has to be computed on that as well. And folks, ADP, Paychecks, all of these payroll services are not doing this for you. Of course, they're going to wash their hands and not be held liable. So be very careful about that requirement. Even if your bonus is paid out monthly or quarterly, you've got to roll it back and prorate it across all work weeks. And if I worked overtime in any of those work weeks, you got to pay overtime on it. There's a short calculation, so if you're doing any of this type of non-discretionary bonus, call me, email me, and I can get you a calculation method that you can put in Excel to do this pretty easily. Now, what we're not talking about here on bonuses is Christmas or completely discretionary bonuses typically at the end of the year. Thank you so much. We had a good year. Here's a turkey. Here's $100, whatever, gift card. That's not what we're talking about. We're talking about incentive compensation, meaning if you do this, we're going to pay you this. There's no such thing as averaging work weeks. If you pay every 2 weeks, and I'm due overtime, and I work 45 in 1 week, and I work 35 in the next, I'm due 5 hours in that work week because overtime is paid on a work week by work week basis. There's no such thing, and you're all going to love this, there's no such thing as comp time, meaning that you give me time off instead of paying me time and a half over 40, unless you're the federal, state, or local government. And that's the disconnect. These folks in the government who pass these laws don't have to worry about paying time and a half over 40. If you are you making any kind of deductions? If you're making any kind of deductions, make sure the employee signs off and understands what the deduction is for, such as maybe you have rental uniforms or equipment or different kinds of things maybe you deduct. Make sure they've authorized that deduction. And then number 2, when they quit or leave, check your state law or call us, because sometimes you can deduct for something they didn't return and sometimes you can't. Certainly you can't hold the final paycheck. So make sure, I just get too many calls of employers frustrated because an employee quit, walked off with uniforms, maybe some tools, a cell phone, whatever it is, and they're desperately trying to get repaid for it, and it's just very difficult unless we have good policies and procedures in place. Next, and you're one of these, if you think about it, next trap is using independent contractors or paying someone as an independent contractor when they're truly not. So you're paying an individual, you may be even paying someone as an independent contractor, and in fact the IRS says they're not an independent contractor. An independent contractor is someone just like you. They're in business, they're advertising, they're providing their goods and services to other organizations in the community. They're hiring their employees. They have a business license. Most importantly, they've got workers' comp, so it doesn't fall back on you. They're invoicing you, etc. Pretty straightforward who an independent contractor is and isn't. It is not an individual who wants to do some work part-time for you. It is not an employee who wants to stay after hours and clean or work around the office or straighten up or do inventory. That's hours worked. It's got to be run across payroll. So if you're issuing 1099s, just make sure that these folks are in fact in business and legitimate business folks and not individuals. Okay? So with that, we're here toward the end. Wayne, I don't know if we made any opportunity or making any opportunity for question and answer. I'll be happy to do that and open up for question and answer as you read those. If you're not comfortable with that, again, please call or email me, and we can offline talk about your specific compensation practices. Okay?
Hey, Bill. We do have a couple questions. They may be a little specific, but maybe I'll go over them, and you can decide, and then maybe those people can reach out to you specifically. But,
sure, absolutely.
Yeah.
Try it.
So the first one is, what percentage of hands-on work? I have management staff that exceed the dollar amount, do manage and spend the majority of their time in the office. They only go out on problem calls. Would they fall under the executive?
I would, yes, because you've hired them as a primary job duty function to be a manager. That doesn't mean they can't do any hands-on work whatsoever. They can still be exempt if they're training an employee. They still can be exempt if they got to go out and address these complicated issues. They can still be exempt if they're going out and addressing a client need, just as long as they're not doing that most of their time. or as a primary duty. So I'm okay with that being an executive exempt person, even though they may be going into the field on occasion.
Okay. We got just one or two more here. We have a salaried receptionist that is the only admin paid under 47K threshold. Does she have to reach that 47K amount by year end, or do we just need to increase her weekly salary beginning on December 1st so that next year her annual salary will meet or exceed that threshold?
This is going to go back to my first comment that I made, and that I cautioned you, and this is a very common, and I predicted it probably would come up. You could pay this receptionist $150,000 and she still do overtime. That sounds smart aleck, but the reality is, as a receptionist, as an administrative person in your office, she is not meeting one of the exemption tests that we went through: executive, administrative, outside sales, professional. So regardless, they've got to meet that test first. They've got to meet one of the exemptions first. Then if they meet one of the exemptions, then you look at their salary. So even if you increase her to $47,476, if she works overtime, she's due it. So you're better off putting her on an hourly rate, or paying her on her current salary and just telling her not to work over 40, or using the fluctuating work week and keeping her on her salary and just paying the half time. But increasing her to $47,476 does not get you out of the woods. She still do overtime. In fact, the overtime is going to be even at a higher rate if you increase her. So that person, you may want to call, and we can talk about that position in more detail. But I hope I made that clear.
Okay, just one more here. If our technicians are paid only on performance pay, meaning they're 100% commission, does windshield time count in the total number of hours worked in a week?
Outstanding. Good question. Somebody knows their stuff. Yes. And I'm glad that's brought up. I didn't cover that earlier. Travel time, whether they're commissioned or not, hourly or not, doesn't matter. Travel time between client to client is considered clocked time. So that needs to go on the time record. That's why a lot of folks are putting in GPSs and or telephone systems or whatnot. So yes, the travel time. So for example, if you're hourly with time and a half over 40, that travel time between client and client goes to that 40 hours or calculation of total hours for overtime purposes. In the specific situation that this fellow asked about, or person asked about, they're on this commission program. They don't have to worry about overtime, but certainly the time must be considered to ensure that they're making $10.88 per hour. So great question. Yes, you must consider travel time. The only time you don't have to consider travel time is from my home to the office, or from the office back to my home. But any travel during the day between clients or from the office to a client, it must be recorded on a time record.